Calls the case of Avalon Housing versus Yolanda Shepherd.
Morning, Your Honor. Jillian Engen for plaintiff.
Good morning, Your Honor. Andrew Campbell, P64391, on behalf of Yolanda Shepherd. Last night, Your Honor, I filed several pleadings, Judge. The matter is a little bit complicated, and I'm not sure if you would, if opposing counsel will be better to describe what's going on.
Your Honor, it's my understanding that there was a flood in the unit. And so I think that the parties are attempting to resolve this. However, my client needs to go in and complete repairs. And so we're trying to coordinate retrieval of Ms. Shepherd's belongings. We're trying to figure out kind of how to move forward. But my client does need to get into the unit and ensure that, there's not going to be entry by Ms. Shepherd. And so we filed the ex parte motion with that intent that the court would give authority to plaintiff to remove and secure defendant's personal property and then dispose of anything that was damaged that's in the leased premises.
And
May I
what
add?
is,
I'm sorry.
go ahead.
Yeah, if I may, Your Honor, just to add to that a little bit, we had a 10-day meeting, Your Honor, and my client was living with a neighbor after this flood, and then May 8th, the county came in and put a tag up and locked everybody out. May 9th, opposing counsel emailed me because the day before I had emailed them asking about the case, and they sent me the pleadings and also the notice to quit and the health hazard. Now, those were served, Your Honor, just so you know, on the same date that these pleadings were filed. So I filed yesterday a motion to dismiss for lack of jurisdiction and a response to the defendant's motion, as well as an answer and affirmative defenses. We are trying to work with them.
Well, let's deal with the jurisdictional issue. What is your jurisdictional issue?
Well, Your Honor, it's my understanding that MCL 600.5714 states a person entitled to possession of premises may, meaning it's permissible, to recover possession by summary proceedings after a person holds over premises. So to hold over, you have to be served the notice to quit. If you send a 30-day notice, you got to send it, give them 30 days to comply, and then file your summons and complaint. Or in this case, they did both a 30-day TOT notice and a health hazard notice, but they sent the health hazard notice on the date of filing. And respectfully, I think that that's violating the law because you're supposed to give them 7 days to get in. And frankly, that's hard to do so when the county has locked you out. And so the court lacks jurisdiction because the requisite requirements by the statute were not met prior to filing. And I listed all the law in my brief, Your Honor, in my motion. Ypsilanti Housing Commission versus O'Day. Plaintiff's termination notice is improper and void. And also Park Forest versus Smith, a proper termination notice is necessary for the court to have jurisdiction. And while the notice was valid in respects to perhaps the content, although we disagree with the assertions, it was not timely. It was not filed in a timely manner. And so my client never had a chance to kind of abide by the demands of the notice. And additionally, I filed a motion for discovery if the court was not going to grant it, because the fire report indicates, I'm quoting from page 1, incident type sprinkler activation, no fire, unintentional. It also states, quote, there was no fire or smoke in the building, end quote. So my client, she wasn't responsible. Apparently this sprinkler, I haven't been in the apartment because we're locked out, but it's cathedral ceilings. It's way up. My client tells me she can't even reach it with a ladder. So the sprinkler just went off and caused all this water to be ejected. She's been, and Avalon has been assisting. They did offer a hotel, but she couldn't get transportation to the kids for school, so she stayed with a neighbor. Now they're offering a hotel again, which we're grateful for, and we want to take advantage of. But my client is poor and doesn't have a lot of money and needs to be able to get a U-Haul and a storage unit. So she went to Faith in Action and should be hearing from them today.
Why are we going through all of this? The unit is untenable, correct?
Well, that's the conclusions they state. They're stating it's untenable, and I don't know I don't know for sure. I don't see any insurance adjusters reports. I don't see anything. There was an inch of water.
I guess I'm not even clear why we're going through this. Under paragraph 31 of the lease, the landlord wants to enter the premises to secure the premises.
Yes, but there's a couple problems with the order and the order that they proposed, Your Honor. Let me get specific, and because I've been through this before. I've been down here for 3 months, and I've seen this before. And it says it's further ordered that plaintiff may remove and secure defendant's personal property from the leased premises. And here's the problem language: dispose of any rubbish, trash, waste, and other water damaged and or flood damaged items contained in the leased premises. That's a problem because any maintenance person.
Then why don't you just ask that they can just look at that your client can look at it? I mean,
yeah, that's what I did in my motion that I filed.
Don't interrupt me. Why are we going through all of this? They need to get into the premises. They tag the unit. They need to get into premises. Otherwise, more damage is going to occur, both to your client's property as well as to the tenant, to the unit. Doesn't make any sense to me why we're going through all of this.
I'm sorry.
If the issue becomes the destruction or the disposal of property, then certainly I think council should be able to arrange that as the property's being removed, your client can be there to try to salvage what property is salvageable.
May I speak, Your Honor?
Go ahead.
I apologize for interrupting the court. Judge, there's a lot of issues in this case. If you look at my motion, my response, the problem we have is we want that, Your Honor. We asked at the 10-day meeting for opposing counsel to contact the county and get the county's schedule when they can come out and open the door for my client. And my client can then go in. Nobody can enter without the county's permission, Judge. Okay? That's what we want. But what we don't want is we don't want some maintenance person looking at the goods and saying, oh, that's water damage.
Why don't you and counsel get together, contact the county, and arrange a time to go down?
I agree.
What is so hard? What is so hard about that?
There's nothing hard, Judge. It's not on me to do that, Judge. It's a plaintiff's case. And we had a meeting. And
counsel. Your client has property that she may want to salvage. It would seem to me that it would be in your interest to contact plaintiff's counsel, get with the county, figure out a time that the parties can go in there. It's in all parties' interest to do that. Your client, the landlord, everybody's interest to get into the unit, get out those items that your client that are salvageable, allow the landlord to go in, repair what's there so that further damage doesn't occur.
I agree. And that's why we had a 10-day meeting.
All right, here's what we're going to do. I'm adjourning this to next week. Between now and next week, I'm going to order that council get together with the county, arrange a time to go into the premises for inspection of the premises and removal of those items.
Thank you, Your Honor. And so at this time, I just want to clarify, Your Honor, you're not entering the ex parte order as drafted.
I'm not going to enter that order. I'm going to enter the order directing the parties to get with the county, to gain entry to the premises. That defendant is to remove those items that she wishes removed.
Thank you.
And then plaintiff is also able to secure the premises and stop any further waste on the premises.
Thank you, Your Honor. Two things briefly, Your Honor. We would like to reserve escrow, or preserve escrow from today's date. Also, the case was filed under 657-14, 1C, 1i after termination of the lease pursuant to a power to terminate provided in the lease or implied by law. Obviously, we can talk about that later. I just want to have that on the record.
Well, that's why I don't see the jurisdictional issue, because I think it's properly filed pursuant to the provision in the lease, but we can argue that at another point. But I'm ordering that, and I'll set this for May 30th, 2025 at 3 p.m. That's in person.
Thank you, Your Honor. Would you like us to submit an order to the court in accordance with?
Please.
Thank
In
you.
person didn't mean I was supposed to be here. I wasn't even supposed to be here.
Thank you. Bishop Pickering versus Andrew Rich.
Good morning, Your Honor. David Fantair on behalf of the plaintiff.
Okay, Mr. Rich. Hello, Mr. Rich.
How you doing?
Okay. How much is owing?
Your Honor, I'm here.
Yes.
They got me here for non-payment of rent, but I paid my rent.
Okay, hold on. Let me see what they're claiming. Mr.
Yeah, I got
Fantera?
my receipt in my pocket.
Hang on. Hold on. Mr. Fantera, how much is plaintiff claiming is owed?
His current balance is $956, and he is correct that he made a payment since we filed the case, but he missed payment a couple months ago, so he's 1 month behind when he makes his payments.
That's not true.
All right. So, Mr. Rich, here's what I'm going to do. I'm going to adjourn this to May 30th, 2025 at 12 p.m. noon. That's an in-person hearing. Why don't you bring all of your receipts to that hearing, and then you can go through them with the attorney along with the ledger and see what's been paid and what hasn't been. Okay?
Right, but what I was trying to say, I get my check, my disability check on the 25th and the 26th every month. I'm always early. I never ever not pay.
Okay. All right, Mr. Rich. I can't decide that right now. That's why I'm going to put it out a week. You bring all of your receipts. They'll have a ledger, and you can go through all of that, or we can go through it and try to figure out if you owe anything or not. All right?
Right, because I got my receipt right here for this month, and I paid it, and the same day that I paid my
Mr.
rent.
Rich, I hear you. I need you to come down next week, bring all of your receipts again with you. There'll be a ledger here, and we can go through it and try to determine if you're missing a payment.
I'm not missing no payments, no way.
Okay, Mr. Rich. That's the best I can do. We'll see you next week. Noon.
What date?
May 30th.
May, we write that down, May 30th. What time, 12 o'clock,
12 noon.
12 noon?
Yes, sir.
Yeah, they got me tripping. They got me saying I'm
Okay.
always, my rent is always.
All right, thank you. We'll see you then.
Will I be coming in person?
Yes, sir.
I would like to come in person because I'm not good with these computers.
Okay, it's an in-person hearing. You'll come right down to the court, bring your receipts, they'll have a ledger. We'll go through it.
Okay.
Thank you.
Yep. Okay. Go. Will you hand me my screen box?
Now go preach.
Court does call the case of Arbor Commercial Realty versus Scott Sendes.
Good afternoon, Your Honor. For the record, Tim Dvorsky appearing on behalf of the plaintiff, Commercial Realty LLC.
Scott Sundays, Your Honor.
All right. And where are we on this, John?
Well, I thought we were going to be able to resolve this, but we were unable to. So I guess we're going to have a hearing, Your Honor.
So what's the issue?
Well, I'm not really quite sure. The tenant wants 6 months to move all of the stuff out. That's one issue. And I told him that we can't provide him 6 months. We can give him a little bit more than the 10-day statutory period. And the other thing is that he feels for one reason or another that there was an agreement that if he moved out, which he still hasn't moved out, that he didn't owe any back rent. Did I accurately?
Correct.
Those
Yeah,
are,
we had a verbal agreement that if I was to move out, that I would no longer be paying the rent. I told him I couldn't pay the rent and move out. And I thought we had come to a mutual agreement that it would be best for both parties if I just moved everything out.
and it's my client's position that no agreement was made. And even if one was, the client still hasn't moved out and still wants another 6 months to move out, Your Honor.
Sir, you're not disputing that the rent's owed. Right?
Well, I am, because I had an agreement with the landlord to, if I moved out, in lieu of paying the back rent.
Which he hasn't moved out, even if there was an agreement, Your Honor.
But I'm in the process of moving out. It's
But
Really, guys, I hear you. You guys can keep repeating it, but I can.
I'm sorry, Your Honor.
From one moment to the next. I get it. So, I mean, there are two parts, so that you understand this, sir. There are two parts of this case. One is the possession issue, and then the monetary issue. In terms of the possession issue, I don't see that there's an issue for me to try, because the condition of you staying is, first of all, to pay rent. Even if, I'm not saying that I'd make a finding that there is, even if there is this other agreement that you move and you don't owe the rent, the only bearing that has on the possession issue is you were supposed to move. Right? So I can bifurcate the hearing so that we deal with just the possession issue and then set it for a further hearing as to the money claim. But if I do that, then the question is when are you going to move? Because I think they'd be entitled to a judgment for possession. And the reality is that if I do that, finding no tribal issue on the issue of possession, it's going to be 10 days. I can tell you that even using my discretion, I wouldn't give you 6 months to move. So if we just deal with that part of it, when can you be out?
I mean, I said realistically 6 months because there's so much stuff. I understand that that's not agreeable with them. But I've tried to work with them. I even offered another solution to conduct a liquidation auction. But I said, even that's going to take, probably 2 months realistically, and everything still won't sell. So I did make a promise that I would clear the property out in lieu of not paying rent, but I would make sure that it was, left empty. And that's why I came up with the 6 months, because I know that's still going to take time. Even after I liquidate a vast majority of the stuff, it's still going to take time to remove the junk. And I'm willing to pay for the removal of all the trash that's in there and leave it empty. But I don't think that's agreeable.
Well, they've said it's not agreeable.
The other problem I'm having is I just found out recently, a few minutes ago, that the person I've been dealing with apparently is no longer the owner of the property. So the person that I've been dealing with, the person that I had a verbal agreement with, I guess is no longer, making the calls. And I was not aware of that, which I guess explains why I haven't heard back from the person that I had made this deal with, because I just found that out a few minutes ago.
Well, Your Honor, speaking to that aspect only, the owner's still the owner. The son has been managing the property for the last year or so. So I don't know I think that's what you're referring to, correct?
I guess I just meant I wasn't aware that the person that I was talking to isn't actually running the operation anymore. So when I was told, I won't charge you any rent if you can move everything out, and at the time I talked to him last, I didn't give him a time.
That's, again, the problem with that is, if I assume that's true, you haven't moved.
I'm in the process.
Which means if you haven't moved, that means you still owe the rent. Right? Which means they'd be entitled to a judgment and you'd still owe the money.
But the agreement that I had was that I wouldn't be paying anymore if I moved out.
But you haven't moved out.
Correct. I'm in the process of moving out.
Well, according to his own words, Your Honor, that's a 6 months ordeal. So, I mean, I could say I'm moving out of my house by taking a dish at a time.
Well, this isn't a one bedroom apartment. This is a 10,000 square foot warehouse packed to the rafters with stuff. So it's not, it took several years.
I get back to my same question. For you, how much time are you looking? 6 months is not going to happen.
Okay.
So here, just let me finish this. The statutory period would be 10 days.
Right.
I get the circumstance that you're in, so maybe that's not realistic that it's the 10 days.
Right.
But I can tell you that even if I use the furthest reaches of my discretion to give additional time, it's not going to be near 6 months.
Okay.
And so if you guys can't decide, I'm going to pick a date on the possession issue, and then I set it for trial on the monetary issue. But you guys are going to have to decide. It's going to have to be something realistic, sir. I mean, they're entitled to the possession of their property by even what your agreement was. They're entitled to possession.
I mean, I can guarantee I can't move everything out in 10 days. It's not.
How much, what would be the fastest?
I mean, 4 months. Is that agreeable?
No, that still puts us in the same position.
It's like I said, I've probably moved half of it out within the past, 3 months. It's going to take, I would say, at least 4 months, realistically.
Now,
we'll let Your Honor make that decision.
I've listened to everybody. As to the issue of possession, I'm going to find that there's no tribal issue as to the issue of possession only. I'm going to issue an order of eviction on or after June 30th.
After what, June 30th, Your Honor?
Yes, June 30th.
Thank you very much.
I will also on the damages and money issues on the case, I'll set a trial on that matter for July 15th, 2025 at 9 a.m.
Thank you. And I will prepare the order on the possession. I'll submit it to the court. I'll submit a copy to you.
Will I be getting a copy? Because that's the other thing. I haven't received any court summons or anything.
Well, we have a proof of service in the file, Your Honor.
What do you mean you haven't received any summons?
The only summons that I received was the one that was taped to the door, and
that's service.
I was under the impression that I was also supposed to be mailed something as well. The one that was taped to the door had the address in Saline, which is why I wasn't here at noon, because I went to the courthouse in Saline and they said, "Oh, you're at the wrong place." And then I called the number that was on the summons, and the number was for Wayne County Courthouse. So my summons that I received on the door was riddled.
So what do you want me to do with that? You're here. I've heard your case.
I'm just saying, am I going to receive?
Yes.
Mailing?
I'll tell you what. Here's what we'll do. You'll get a judgment. Prepare a judgment. I'll sign it and I'll give you a copy. Thank you.
The judgment up at the counter.
Yes, get a judgment out at the counter, sign it, and then get it all prepared, and then I'll do that.
Thank you.
Northfield Estates versus Carl Riemann.
Denise Arsenal for the plaintiff.
Is that you, sir?
I'm Carl Riemann.
All right. All right. This is a termination case, and you adjourned us out for you to seek the advice of an attorney. So where are you now on this case?
I adjourned it to seek advice. I failed to get any attorneys to get involved. I got warning that I'd be postponed a week last week, and then that never followed through to get anything more further done. I just counting on my Apple phone for a computer these days. I'm just, a lurch of, was just living as feeble as I am these days with, my brother just got committed to hospice this week, and I'm just mixed up with, just trying to pay off, see how I survive my sewer bill or my gas bill, I should say, for over the winter time. And then the surprise of Northfield Estates not accepting, refusing April's rent. I never got, I guess I get answers. I guess anything to do with the management, it's like answering a question with a question. And it's just like, change the subject to just keep me confused is all. That's my best defense I have with my management. And just fix this, fix that. Like I'm just a, bleeding deacon of money. And I'm just trying to balance out, that they say things, they like my first initial leak was a back bathtub leak, and the water got in, and around to my back porch enough to surge the porch up, so my porch is pushed up in the back, and that with the winter freeze, and so just that's just all of a sudden that just crushed that, and it's like, gee, I know I have some ideas to fix it, and and then it just I just don't, I just stay terminally confused. I don't know how to. My best defense is confused. I'm seeking lawyers. I guess I would just get real frustrated with getting callbacks and any direction to go fixing my, I guess the latest one.
But they're alleging they're trying to terminate your tenancy. What's your defense to them terminating your tenancy?
I guess what's I guess so. Just what's my response to that? I guess fix my front door. My front storm door was their latest thing that they put to be a diligent thing to fix, and they're saying that when it was still frozen in the ground because the hinge broke off, and I'm gonna fix that, and then fix my skirting and.
Have you got all of that? You don't have it all fixed.
I don't have it all fixed. I'm plenty busy with trying to find my balance of money, and my older brother, last of my family to be on this side of the grass that has been kind of troubling me. And I guess, just communication with the management it's just answer a specific question or ask a specific question and it gets switched to something else. And it gets so frustrating. It just helps encourage ADD or something. I don't know. That's my nicest way to put it, I guess.
Your Honor,
Sir, yes, go ahead, Ms. Fentanyl.
Thank you, Your Honor. So this is a termination for just cause based on failure to maintain the appearance and yard upkeep. I have received updated photos from my client as of 2 days ago. The home and site are still not up to community standards by any means. I do show that Mr. Ryman painted his home. That it's still not up to standard. The skirting's not fixed. There's a ton of trash on the site. There's a ton of trash on the deck. The deck still needs to be redone. There's a lot of condition issues that are still existing as of today.
Well,
and you're not disputing that. You're just
no. I'm just, first of all, I guess the paint was painted when my wife was still alive. That she passed away early 2022, and and we went through the process, a park approved color, and painted that, and then I had some T111.
So you're admitting that the skirting isn't up. There's
the skirting
issues with the deck. I think you mentioned something.
Yeah, skirting in the back was not really visible. It's
well, but you still have to paint it.
Yeah,
all right. Look, sir,
I guess excuse me, Your Honor. I guess the park approved color for my paint, I guess I just want to add in, like the modern day, I guess I'm surrounded by aluminum siding mobile homes, and I have T1, wooden siding one, and the park approved color thing. It's like, gee, just No, we went through the process to be approved to color to paint it. And so it's just changed the rules, gets to be just difficult. I don't know, move the goalpost. I said it right to Jeannie's face, the manager, you know, change the goalpost, makes it a little change the goal line. It just keeps me in everlasting confusion. I don't know.
All right. So here's the deal. I don't see anything I can try. You've admitted that you haven't kept the property up to standards regarding everything. And I'm not even necessarily talking about the paint. I'm talking about there are other conditions on the premises. So I'm going to find that there's no tribal issue for the court regarding that. I'm going to grant a judgment for possession and termination of the tenancy with the writ date of June 6, 2025. What I suggest you do, sir, is, you know, you either have to move or you're going to have to figure out a way to get out there and try to get the done and deal with management.
Deal with management. I guess then she can reverse this?
Well, they can, if they choose to, they can work with you. But I think quite frankly, sir, there are things that you're going to have to do to try to make sure to get that property up to community standards. Thank you.
You just waiting on Sycamore, and those sound like the right numbers to me.
Okay, now are you gonna yell at, are you gonna yell at me again?
Not,
You did it last time.
I love you.
Are you gonna yell at me again? There's nothing I can do. No, you came in here.
You're the best person ever. I watch you every day on YouTube. Like, come on.
Okay. Well, thank you for that, I guess.
Are you kidding me? Oh my God. You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. You need an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Green? We're going to start bringing people in person. We're going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it? Okay.
Come and go, so let this feeling go. I'm sitting up here, I'm the one that needs a drink.